Hello.
Hey Nicole, yeah, you're all ready to start. I think we'll figure out the name situation there. There it is. And
Perfect.
yeah, then you're good to start.
Okay, perfect. Hello, everybody. My name is Nicole Cote. I work at Abdenor Weicker. I'm an attorney in our Michigan and Ohio offices. I practice in the areas of employment, student rights, Title IX, and general civil litigation. Uh, just a visual description of me. I have brown curly hair and I'm wearing glasses with a gray blazer and a light blue top. I'm located in Southeast Michigan in the Temperance area. So I'm in Michigan and Ohio a lot. And fun fact about me is I have run 4 full marathons. And as cliche as that is, training for those really changed my life and my perspective on doing hard things. So I'm excited to be here today talking to you about the constitutional rights of students in the Schoolhouse Gate. And we're specifically going to be talking today about the First Amendment. The First Amendment language reads that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people, peaceable to assemble and petition the government for a redress of grievances. So that is a lot of words. There are 5 rights that are enumerated in the First Amendment. Some facts about this is it comes from the Bill of Rights in the Constitution. And even though it is really old, it's only really been litigated in the last 100 years or so. And the bulk of that is in the 1960s, which we're going to be talking about today in the cases. Um, if we can go to the next slide, it discusses more specifically what the 5 rights are that are enumerated in the First Amendment. And those are the freedom of press, speech, peaceful assembly, religion, and the right to petition for redress of grievances. So, what we're really going to be talking about today is the freedom of speech. But as you can imagine, there's a lot of overlap between a lot of these different rights. There can be speech and press, peaceful assembly and speech, and any one of these could take up an entire semester in school, and they often do. But we're going to be just talking about the freedom of speech today. Though it, as you can kind of see here in the symbolism, it's often intertwined with the freedom of assembly and just a brief background of what it means to be speech. There are a couple different types of speech. It can be pure speech, which is often known as spoken words, written words, and it can include actual tangible things that you can read or hear. There is symbolic speech, which are things more like a nonverbal action or a protest, like burning a flag or wearing an armband in protest, which we'll talk about in a little bit, displaying a sign. And there's also something like expressive speech and conduct, which could be marching, assembling, or picketing. And again, those may seem more like an assembly or protest type of First Amendment right, but they're often interwoven together and would be considered expressive speech as well. So, what types of speech are not protected? We know kind of generally that speech is protected, but per anything in the law, something is a right until it is interpreted that there are limitations upon it. So, the types of speech that have been found to not be protected pursuant to the courts are things like obscenity, which is often something that is depicting sexual conduct, or it's just patently offensive. It lacks any kind of political, artistic value. A defamation, which is a false statement communicated as a fact that damages someone's reputation, that often has its own civil litigation, so that's not protected speech. Incitement to imminent lawless action. So that it really can just be incitement of violence. So speech that is intended to likely provoke an imminent unlawful act or riot. Also, true threats and fighting words. Those are spoken words or utterances that are intended to threaten somebody's physical safety or to provoke a violent reaction. And again, speech integral to criminal conduct or fraud and perjury, those are kind of just not protected because they also have a criminal component that would make them unlawful. And in addition to the specific types of speech, there's also restrictions on that can be imposed on the time, manner, and place of speech in public places, specifically as it relates to protests to make sure that they are not too disruptive. So, moving forward into the First Amendment rights of K-12 students, we'll talk about K-12 students first, and then we'll talk a little bit about higher education institutions later on. So, the First Amendment rights of K through 12 students. This was first litigated by or heard before the Supreme Court in the 1940s. The first Supreme Court case that heard it is the West Virginia State Board of Education versus Barnett. And in this case, there was a group of Jehovah's Witnesses that challenged a state law that required all public school students to salute the flag and recite the Pledge of Allegiance. And if students did not do that, then they faced being expelled. And these Jehovah's Witnesses argued that saluting the flag was against their religious beliefs, and which barred them from worshiping idols. And this was a violation of their freedom of speech and also their freedom of religion rights, which are both in the First Amendment. And in a 6-3 decision from the Supreme Court, they mostly relied on the free speech clause rather than freedom of exercise clause in the First Amendment, but they did find that the saluting of a flag was a form of speech, and they held that the government cannot compel students to express a belief without violating the First Amendment, especially as it related to saluting a flag and the religious undertones that came with requiring them to do that when it violated a code within their religion. And within the 1960s as well, there were a few other Supreme Court cases that came through. We have the Ingle-Vital case in 1962 and then Eblington in 1963. And both of those cases overturned state laws that mandated prayer or Bible reading in public schools. And that's probably for a few different reasons, both prayer and Bible reading in public schools, that's related to religion. So similar to the Jehovah's Witnesses in the Barnett case, if it directly conflicts with other students' religion, that's pretty clear that that's a violation of at least the First Amendment as it relates to religion. But they also found that there were some speech components as well, and those really started to set the tone for the biggest case that's the precedent even to this day, which is Tinker. Any litigation is most likely to cite this case. It is from 1969, and in this case, there were 4 children in the Tinker family that decided to wear black armbands to protest the war in Vietnam. This was seen as a solidarity trying to call for a truce with the war. The Vietnam War was very controversial at the time. There were protests happening all around the nation to fight it. A lot of people disagreed with the war. And when the school heard about the Tinker's plan, it wrote a policy that said that any student wearing a protest armband to school would be asked to remove it, or they would face suspension until they were willing to do so. That's a very specific policy, clearly targeted at the Tinkers and their plan here to protest and also engage in expressive speech to, be against the Vietnam War. And so the school made a policy thinking that if they have a policy, they would be protected in disciplining the students. So what happened is the students wore the armbands in protest, and unsurprisingly, they were suspended from school, and their parents filed a lawsuit alleging that this was a violation of the students' right to free speech under the First Amendment. And the question before the court was whether the protest was symbolic and should it be permitted on the school property. And the court found that in a 7-2 decision that the school's policy did violate the students' right to free speech under the First Amendment. So this is the first time that the court finally sat down and created a test to help schools and students and everyone really dive deeper into just reading whether or not something would be a violation of the First Amendment. Up until this point, a lot of the cases were very fact specific. The court didn't expand too much into what would be a violation or what would not be. So they developed a test that is still used to this day called the substantial disruption test. And basically the court recognized that there would be valid reasons on why a school might restrict free speech of students on some occasions, but this case just did not meet that test. The question is whether or not the speech of the student would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school. Now, as you can imagine, now what's being litigated pursuant to the substantial disruption test is the disruption material? Is the disruption substantially related, or does it interfere with the requirements of the school? So it provided a test for everybody to analyze this fact-specific circumstances under, but even now, whether something is disruptive, whether it's materially related, as we'll see from some subsequent cases, it's still litigated and it's still a case-by-case basis, very fact-specific question. So the goal of the court here was to say, if the school administrators are going to limit the speech of students, then the school needs to be able to demonstrate that the speech would interfere with the requirements of the school. And ultimately, with Tinker, they found that the wearing of armbands did not cause a substantial disruption, and the suspension of those students was deemed a violation of the First Amendment rights. So Tinker here really set the parameters on what free speech looks like on school campuses. Like I said, it is regularly cited by the courts, and a great quote that comes from this case that I think really is foundational is students do not shed their constitutional rights at the schoolhouse gate. So yeah, I just think that's really a great quote and a good, great enumeration of rights of students at school. The next case is Bethel versus Frazier. This one is from 1985, and this court specifically analyzed the question of the limit on speech as it relates to obscene and vulgar speech. In this case, a student, it's Fraser, he was a champion debater at the school, and he gave a speech that was very sexually graphic. It had a lot of innuendos on it, and he gave that at a speech assembly when he was nominating his friend to be the student body vice president. And beforehand, there were two teachers who reviewed the speech and told him it was inappropriate, and he could not give that speech, but he decided to do it anyway. And I'll spare the details of what the contents of it was, but as I said, it was a lot of obscenity and vulgarity and a lot of sexual innuendos. And the reactions from the students in the school in this case is what the court really honed in on, which was that students were like hooting, hollering, they were really loud, they were making a lot of hand gestures. Some students were really embarrassed and they were affected by the nature of this speech. And there was also a teacher who lost some class time because she had to have a debrief with her students to discuss what the speech was and kind of just discussing it with her students. So as a result, Frazier was suspended for 3 days, and he was also removed from the list of candidates for being a graduation speaker. And as a result, he was told that he violated the school's conduct policy, which prohibits any type of behavior that substantially interferes with a student's education, including the use of obscenity, whether in language or gesture. So the school's policy here really integrated what we talked about in Tinker, which was that, substantial disruption standard. The school had a policy that said if you create a substantial disruption that interferes with a student's education, then that would be a violation, which would make you subject to discipline. So ultimately, this did go before the Supreme Court, and the court did rule in favor of the school administration here, holding that there are legitimate restrictions on free speech. So Tinker kind of set the tone. They said that specific speech was not, that was protected speech, and the school could not limit that at all. But of course, now there are going to be subsequent cases that are challenging what free speech is and what is disruption. So the court found that while adults generally can use offensive language to communicate ideas, it's not expected that schools would give students that same latitude, especially because they have a mission of educating students and imparting different values. And they also noted that the school's policy very clearly stated that using obscene language that would carry a consequence, and the student here knew that, and he still chose to do that anyway. So schools do have a wide range of latitude to deal with these types of actions, and they kind of have an obligation to prohibit lewd and indecent speech that disrupts the educational environment, even if it's not legally obscene and would meet that definition outside of school. So, going back to that Tinker quote, students don't shed their constitutional rights in the school gate. But when you're in the school gate, there kind of are heightened expectations and responsibilities that the school has to take in order to protect the other students that are around the student who may be engaging in the speech. So, as it's seen here, the biggest disruption most likely was probably that a teacher had to take time out of her day to discuss this with her students. So you're affecting the ability of other students to learn. Other students were reacting in a loud way. As does happen with Supreme Court cases, there were some dissenting opinions. It's a big win for schools in this case because it provided them a win and gave them some specific things to hone in on if they want to have more regulation of student speech, and they can now crack down on obscene speech. Some other cases here have upheld the prohibition of speech that supports drug use. Um, that includes, the Sixth Circuit found in 2000 that um, they upheld the suspension of a student wearing a Marilyn Manson t-shirt, and that singer is often known for their drug use. Another one is Morse versus Frederick. This is from 2007. Students had lifted up a banner that said "Bong hits for Jesus" during a school assembly, and this was found to not be protected activity by the First Amendment. The next is Barr. This is from the Sixth Circuit in 2008. And this one upheld a dress code at the school that banned the clothing that displayed a Confederate flag. And it's interesting because this is just from the Sixth Circuit, but it seems to be somewhat at odds with Tinker if you're looking at more so a protest or some kind of expressive clothing here. But the court noted a lot of considerations that led to its conclusion here, which included existing racial tensions, violence at school, and an increase in absences of students who didn't go to school out of fear. So ultimately, the school was able to establish that this clothing would likely cause a substantial and material disruption. And this is interesting because I don't, if the court found here that it was likely to cause a substantial and material disruption, which means that there may not have already been one, aside from students maybe not going to school out of fear, but it kind of puts into school's mind that maybe it can establish a substantial disruption that could be anticipated, even if there's not specific evidence of it at that very moment. There have also been a couple other cases related to speech being permitted that's offensive, even if it's not lewd or vulgar on its face. And this couldn't, for the case that's on the screen today, this is a Middleborough case from 2025. This was from Massachusetts. Ultimately, it never went to the Supreme Court. They denied cert of hearing the case. But in this case, the student here wore a shirt to school that said, "There are only two genders." he was asked to leave the school, and then he returned to school wearing a shirt that said there are censored genders. So clearly, this is some kind of speech expressive protest of the school trying to have the student not have something that said there are only two genders. Ultimately, the court here found that they upheld the right of the school authorities to suppress this expression from the student. And they found this because ultimately the speech, similarly to the expression earlier with the Confederate flag, I think this is from 2025. So in today's climate, the question of genders, the question of two genders, more genders, it's becoming something that could be very personal to people, could make people feel unsafe and unseen if they're told there are only two genders, but they may not identify with that. And especially in today's climate, I think there could be argued that there would be a substantial disruption if the student were able to wear something like this that was so polarizing and divisive among students. So um, ultimately, it was upheld. Unsurprisingly, there were some dissenting judges from the Supreme Court who believed that the students should be able to wear speech like this. That did come from the conservative judges on the court. The next category of speech is what is considered to be school-sponsored speech. And this comes from a 1988 case of Hazelwood. And in this case, there were three students. Well, and just to kind of back it up a little bit, school-sponsored speech is essentially speech that a school could say that the speech on its face makes it appear that the school is adopting what the speech says because it comes from some kind of production within the school, like a school newspaper, a yearbook, something that is a direct output from the school with its name on it. Students may produce it and create the speech, but ultimately there's an implication that the school would be adopting the speech and therefore making it appear to be sponsored. So in the Hazelwood case, there were three students. They were journalism students who filed a complaint with the school, uh, or filed a complaint that the school, the principal, and their teacher had violated their First Amendment rights because they deleted 2 pages of articles from the school's newspaper. And the school here they published the newspaper. They made sure it was distributed to students, faculty members in the community. And the principal here banned 2 articles. One was concerned with student pregnancy, and the other was concerned with, parents of students who were getting divorced. And the students here argued that the principal was not justified in suppressing these articles because they did not cause a material or substantial disruption of the educational process. So here the students were relying on that Tinker standard and saying, first of all, it wasn't even published, so there definitely was no disruption. And it would not be reasonable to think that the contents of this speech would create substantial disruption. So because of that, they argued removing the articles was a violation of their First Amendment rights. Ultimately, here, they believed that the newspaper should be viewed as a limited public forum for student speech because it was relevant and related to the interest of students at the school, so they should be able to express whatever they wanted. The school here argued that it had not created a limited public forum for this kind of expression. And they looked at the overall context here and they said that this was very teacher controlled, it's principal control environment, and this is not really viewed as conveying only the ideas of students, but the newspaper itself is conveying speech on behalf of the school. And the court agreed with the administration here. The court rejected the arguments of the students, and they created a new rule that complements what came from Tinker. And that rule is that if certain expression even if it involves students, is reasonably perceived to be school-sponsored or endorsed by the school, then the school may restrict that expression as long as it is reasonably designed to promote a legitimate pedagogical concern. So this was interesting because the judges here debated between themselves on whether or not a newspaper should be viewed as an expression on the part of the school or if it should be viewed as students and their own expression. And so there's a lot of dissents here kind of arguing that, but essentially what came from this is a wide wave of schools that created a new policy. A lot of schools created a policy basically adopting the Tinker standard of proactively saying if you do speech that's a material disruption, then you'll be suspended. A lot of schools here also made policies that made a disclaimer that made it explicitly clear that what is in the school's student newspaper does reflect the views of students and the school. Um, and so it kind of creates that school-sponsored speech disclaimer within the school. Some of them may say it is a student newspaper not related to the school at all, so they really create that distance of not being school-sponsored. But those who may want it to be connected may make that explicit disclaimer. Uh, and some state legislators have also passed laws saying that newspapers coming from public schools exist for the expression of student speech. And because of that, they cannot be suppressed by the school. So really, yeah, and that, so yeah, ultimately what came from that is, if it involves students but is reasonably perceived to be school sponsored, it could be an issue. So, more litigation to come on that, I'm sure. Another hot button topic in the K-12 area is social media and internet use. So we've talked a lot about what happens on school in a classroom assembly, but what happens when a student is making social media posts outside of school? What is the right of schools to limit that speech? And this is still being pretty litigated. Um, Ultimately, what has been found here is that a school may be justified in responding to off-campus speech if it includes a serious or severe threat or bullying or harassment to particular individuals, if it's a threat at students or teachers, if it fails to follow certain rules about lessons or writing papers, or if there are breaches to the school security devices. And there have been a couple cases that have interpreted this in recent years. One case in the Western District of Pennsylvania held that a student's off-campus Snapchat messages were not protected and could be punished by the school because the messages were not merely profane, but were actual threats targeting a student. So targeting the life, threatening to hurt another student, that's often probably going to be found to not be protected speech, and the school would be able to discipline that student. Another case from the 10th Circuit actually found for the student in that case, holding that even though she made racially offensive social media posts, it was protected by the First Amendment. Of course, there's a caveat there that if the school could provide that it caused a substantial disruption at school, then, maybe there would be an argument to doing some kind of discipline in the First Amendment. So, um, the question here, as I kind of said earlier, is that some courts are finding that there already had to have been a substantial disruption in order to regulate the speech. But some courts are starting to interpret that question to allow schools to think forward if they can reasonably interpret that there could be a substantial disruption. So they want to do discipline almost proactively. And the question I think that will come from courts is, how far is too far? How can you really perceive whether or not a substantial disruption is likely to come from speech? And of course, all of these are case by case basis, fact specific, but they do provide some guiding principles for students to understand their rights, but also for administrators and schools to understand how far they can go with enacting discipline and policies to protect the interests of the school environment and other students, and also balancing that with the constitutional rights that all of the other students have for speech and expression. So just a summary here of some of the K-12 rights here. And again, all of these cases are going to be fact specific, case by case, what was said, what students were around, what effect did it have. But just generally, courts have found that students are free to opt out of the Pledge of Allegiance. They can distribute materials about political, religious events as long as it's respecting time, place, and manner limitations. They can wear clothes and symbols that may represent their gender and cultural identities. They can do walkout and silent protests and express themselves on social media as long as they are doing it on their own time off campus and it does not substantially disrupt the learning environment at the school. And some reasonable things that are often not protected for students, again, is it substantially disrupting the learning environment for other students or teachers? If the student engages in vulgar, lewd, obscene, or plainly offensive speech, or they make threats of violence, if they're using school-sponsored activities to express viewpoints that are not consistent with the school, if they wear clothing or symbols that have historically been inciting violence or really just targeted to making one demographic feel really unsafe. Usually those are racist, homophobic, or anti-religious materials or if they're damaging school property. I mean, you can write I love you on like that's not necessarily any kind of these prohibited speeches, but you can't, graffiti that on the wall. Like that wouldn't be protected. That would probably violate a law too. And and next, again, what is that standard of what it means to be a material and substantial disruption? Courts are still analyzing this all the time, but some guiding principles really are, is it interrupting class or instruction? Is it a threat of violence? Is it racially harassing? Is it fighting? And schools are required to have evidence that a disruption will occur in order to limit speech. So, students that are trying to engage in any kind of protest, it's important to really think about what impact that may have on the school environment because that's the limitation that you would be held to. And again, what is considered a school-sponsored speech? School-run publications, school run plays, any activities and athletic events, or anything that is clearly designated as being sponsored by the school. Those are going to have higher protections for the school and less freedom for the students. And a poll question here is, are the constitutional rights for higher education students the same as K through 12? So I will leave that up. And whenever you're ready to move forward, Elizabeth, I will be ready with you. A lot of people saying no. Interesting. Ready to move forward whenever you are. Okay, so we're going to move now into higher education for students in free speech rights. So, somewhat similarly here, somewhat different. Students at the undergraduate and graduate levels do retain significant First Amendment rights, but of course, again, they are not absolute and they are subject to reasonable restrictions. And it is a different standard that applies to public schools and universities versus private universities. Free speech at public universities. So public universities are bound by the First Amendment, and they cannot restrict speech based on its content or its viewpoint. So again, they can restrict speech based on making sure it's in a neutral time, place, and manner, making sure that there's no substantial disruption to the school. And a lot of the same protections are here at public universities as far as wearing expressive clothing. You can distribute flyers, collecting signatures for petitions, campaigning for change, and participating in peaceful protests. some examples here of what could be a substantial disruption. Mostly you're looking at, does it affect the physical environment of the school? Is it affecting the classrooms? Is it blocking entryways? Is the speech calling for some kind of lawless action or being threatening? And again, clear, unprotected speech that would be obscenity, defamation, or violence. And I think what probably one of the biggest distinguishing things from a university with college students versus those in a K-12 setting is the effect that speech on its own could have on a student would probably be less of a disruption than it would be in a K-12 setting. Um, maybe a bong hits for Jesus at a public university may not be as disruptive as it would be at a middle school with seventh and eighth graders. Or, so the context of everything is going to matter with what is a substantial disruption. And I think because of that, there would be a lot more uh, freedoms for students at universities than a K-12 setting, at least for public universities. Now, private universities, they are not generally bound by the same First Amendment principles because they don't receive that federal funding most of the time and they may not be considered to be government entities. But a lot of private universities do voluntarily commit to upholding free expression of students in their own policies and code of conduct. It should be assumed that private universities would want to uphold the expression of their students, but at least they are enumerating it in their handbooks. And when they do that, it is then considered like a contractual obligation, and they have to adhere to that for the rights of students. Now, some states, including California and Ohio, they have statutes which extend the First Amendment protections to private colleges and universities, even if they're not necessarily bound by those principles within like the United States Constitution. So Ohio has one, nothing in Michigan or Pennsylvania. Hopefully they will make some. But those are great when they're enumerated because you're protected as a student on all kinds of grounds. Now, if these private institutions do receive federal funding in any way, they would be subject to the federal anti-discrimination laws like Title VI and Title IX. And it would require them to address any kind of discrimination based on protected characteristics. Now, some issues that are coming up in higher education speech areas is hate speech. Again, hateful or offensive speech can be addressed through educational initiatives and a university statement. It's often not grounds for censorship under the First Amendment unless it rises to the level of harassment or is a true threat. So I think if they would have a little more freedom here in the university setting as students as opposed to a K-12 setting. And a unique consideration issue for higher education students are the rights of non-citizen college students. So a non-citizen college student generally has First Amendment rights, but there are limitations to consider that they should be aware of as adverse consequences. So sometimes if students are protesting and a student gets arrested, an adverse consequence of being arrested when you are not a citizen is that could have issues with your student visa or your ability to remain in the US. So just some negative consequences that could be affected by a non-citizen college student that a citizen college student may not experience. So, and the government has a lot of power over those students to be able to affect your visa and deport, especially in today's administration. So just some things to take into consideration to be careful with that. And okay, so another interesting recent issue is the case in Columbia University. And this one became an epicenter for pro-Palestine protests, and it highlighted the difficult task that universities face in balancing free speech and the safety of the other university students. And in this case, there were a lot of pro-Palestine student protests, including tent encampments, and they were in the common areas of the school. It became a big point of contention. And obviously the argument is that the school started expelling students, suspending them. They revoked the degrees of some students, and that caused a lot of contention because it felt like they were limiting the speech of students. And of course, the university said that the punishments were due to disruption of the campus library and disruption to academic activities, really honing in on that disruption language, which violated university policies. Students argued that their actions were comparable to other protests, but of course, the school disagreed. So ultimately, Columbia here has faced a lot of backlash from all sides. I don't think anyone was happy with what they did for any reason. And, they faced backlash from the Trump administration, really wanting them to hone in on disciplining these students. They lost a lot of funding. Students were upset. It created an unsafe environment. A lot of students felt. So, a lot of lawsuits going on with that. It'll be interesting to see what comes of that. But it did bring a lot of focus to, the limitation on rights of students for protesting something that was very politically active, and still continues to this day. But it also had a lot of action from the administration, which is kind of new. So interested to see what happens with that in the future. So another little summary of higher ed students' free speech rights. So again, somewhat similar to those in K-12, but you can opt out of certain things. You have a lot of rights with, we can go to the next slide. You can wear clothes and symbols that represent gender and cultural identities. You can do walkouts. You can do protesting. But again, you cannot substantially disrupt the learning environment. You can't engage in obscene, harassing, or violent speech, and you can't wear clothing that would incite violence or create a fear for other students. And finally, the question is, what's a material and substantial disruption for a higher education institution? I think, again, what is a disruption for a K-12 school is going to be different than a disruption for a higher education institution in some circumstances. Recently with Columbia, it could be argued that those encampments are setting a tone of a new wave of things that could be deemed to be disrupting. If they were encamping and not making any noise, is that a disruption? Is it the noise that's an issue? So generally, it's seen that if you're interrupting class and you're affecting the instruction, threatening, those are going to be considered a disruption. Hate speech, again, is there's no real true definition of hate speech, but it's considered fighting words, inciting violence, intending to inflict injury, or really just affecting the peace of others. And so unless it has a likelihood in immediate physical violence, then even if it's just offensive or disagreeable, it may not necessarily be hate speech that could be regulated. So that is all I have today. If anyone has any questions, if not, I hope this was a helpful presentation for student rights and free speech.
Thank you, Nicole. That leaves a few minutes that we could take some Q&A if there is any. We'll just open it up for a few minutes and see if anything's dropped in the Q&A box.
Okay, thank you.
While we're waiting too, I'll say that there were some questions that were asked at the end of last session that we ran out of time. And I didn't mention this at the beginning, but we'll any questions that we don't get to either from the speaker or we don't get answered through the Q&A during the session, we're putting on a list so that we can address those at the panel discussion. We have a panel discussion at the end of today and tomorrow. So we'll have those, and any that we can answer if they're very specific to your circumstance or specific to a set of facts. We can even answer those, have the presenter answer those by email too. So either way, we'll get those addressed, but we have compiled a list for the Q&A at the end of the day. And looks like a couple questions have come in. One is, it says, are there laws about hate speech at schools that have been challenged? If you know, Nicole.
That's a good question. I don't know anything specific on hate speech laws. Generally, I think if something is deemed to be hate speech, it would be um, I mostly just focus this on schools, so it may be deemed on the school's policy of what they determine to be hate speech, and maybe that could be fought on. But um, yeah, I'm not, I would have to look more into the specific laws on it, but generally, I don't think that would be something challenged. I think it would probably overlap with something else that would have limited the speech.
All right. And then in the Frazier case in particular, the question is, am I correct in understanding that it was more about the school policy than following the Tinker substantial disruption standard?
Yes, I think that's a fair assessment on Frazier. Ultimately, I think the school's policy was based on the Tinker Substantial Disruption standard. So I think the school, by making that policy, they kind of proactively enacted what Tinker had set. So I think it was twofold that it violated the school policy and the school policy was in line with Tinker, and therefore the court was willing to adopt it. I think if the school had a policy that was unconstitutional or in direct contradiction with something that the Supreme Court has said before, then, the policy would not likely be upheld. So I think because the policy mirrored Tinker, both of them were able to kind of set the framework for that speech being not protected.
Got it. And one more question, a good one. Can we apply the free speech standard, I guess, or can we apply free speech to K-12 students with disabilities? And do they have more rights?
Yeah, definitely K-12 speech protection is all students. Disability, non-disability, any kind of student in any setting, K-12 or not, has these protections that are enumerated by the Constitution. So every student is going to have them. Students with disabilities, they have additional rights pursuant to the IDEA and state laws that would protect them. I don't know if necessarily it would be more rights, but I think a student with a disability, depending on what it is, it may provide context to protect them in settings, depending on what it is that the speech was. I think that determining if something was a substantial disruption or if it violated a policy, they would probably have to take into account all the things like the student's disability. Was their disability related to the speech that happened, especially if there's any kind of significant discipline imposed, and if the school wanted to do that, they would have to do an MDR meeting to address it and whether it was related. So I think it would be important to highlight that on the outset if the student has a disability, and it could, provide some additional rights for them.
All right, thank you. I don't see any other questions in the Q&A. We have about a minute left, so I think that'll be perfect to give our attendees time. If you click on the link in the chat box, we're going to look for evaluation number 2, which should be one of the most recent posts. And if everyone would just complete evaluation 2 for Nicole, then we'll take a 10-minute break and be back at 11:10. Thank you, Nicole.
Thank you.